H-1B layoffs, work visa holders are being laid off. For the past few months, this has been in the news so much. But what are the options available to these visa holders who are here temporarily as per USCIS, as per DHS, but in some cases, really not temporarily because H-1B is also a dual intent to visa, right? So, what happens to those visa holders who are already here? Been living here for maybe over a decade, already have I-140 approved, which is really just one step closer to their green card. But then you know how it is, the green cards may or may not come in their lifetime, especially if you're an Indian born national, right? So, how does the layoff impact a person who's been in this country long enough, who's literally given their blood, sweat to this country, not to mention social security, which they are never gonna come get back, right? So, what happens to all of this? I'm joined by attorney Ishan Anand from Chugel LP, and he's going to be talking about all of this with me today. I'm American Alien, and welcome to the American Alien podcast. Attorney Ishan Anand, I'll be very sure to put all your credentials in the description box so that people know how to reach out to you in case they need a consult, or people can actually reach out to me and I can connect you to Ishan. We actually work together at Chugel LP, and we decided that, it'll be good to really talk about these issues in detail. So here we are. So Ishan, what are some of the distressed news that you're reading? What is some of the confusion that you feel people are in, because information is coming from all sources. One attorney says go on B1, B2. The other one says if you have I-140, why don't you apply for a compelling circumstances EAD? The third one says 60-day grace period, but we don't know. I-94, if that's valid for you, you have 60 days. If not, then you'll have to calculate how many days are really remaining. So there's just so much information that needs to be processed. I want you to break it down for us today.
Okay. So desperate times call for desperate measures.
Yeah.
There is like no one size that fits all. Uh, we have to decide case to case basis. When we evaluate a case, then we can tell what's the best option. Uh, Sometimes the option can be B1, B2 when a person wants to go back to India. Meaning that if a person is saying, you know what, I want to go back to India, but I need some time and maybe 3 months, 4 months. I need 3, 4 months, and then so to pack up everything and leave. And in that situation, we can switch to B1, B2. The reason is that um, they get at least 3, 4 months, 5 months time,
Yeah.
and then they can have prospects to come back and visit US in the future, right? So right now they can just pack up everything in 3, 4 months and then leave the country so that to some later
Yeah.
date, if they want to visit the
Yeah.
US, they can come back. That's one option if somebody wants to go back. If
Yeah.
somebody doesn't want to,
Yeah,
uh
but I just wanted to say, B1, B2 could be a good option for in case you don't get a job. I mean, the job market is really tricky at the moment, right? No matter what we are reading in the news, it's not easy, right, to get a job in this market. Secondly, don't you think it's kind of contradictory for an H-1B to apply for a B1, B2, given that, in one case you are showing dual intent that you want to immigrate to the US, and B1, B2 is really just a tourist visa or for business purposes in that sense.
yeah, but in this, as I said, if a person wants to go back, because now the person is showing intent, then okay, I want to go back, and I will go back once my lawful temporary status expires, and I want to change my status from H1 to B. Uh, so to get some time to pack up everything, because a person, if suppose, think about it, a situation where somebody is living in the US for maybe 10 years, right?
Yeah.
I assume they might have also filed the green card petition, like I-140,
Yeah.
not the adjustment, but
Yeah.
I-140. So they showed intent to migrate even.
Yeah.
So not now they don't have a dual intent. Now they have showed intent that they want to migrate to the US.
Yeah.
But now situation can change. Intent can change um, today. Suppose today I say, I want to migrate to the US, and tomorrow I say, no, I want to go back. So if somebody has true intentions to go back, and that person wants to just have some time, maybe 2, 3 weeks, 2, 3 months, 4 months to pack up everything. There are loans when you live in the US. You may have housing loan, you may have car loans, you may have
Yeah.
pending transactions, stocks, here and there stuff. So you want to pack up everything, maybe lease. They're on their lease, so they don't want to ruin their credit. So if they want to go back, yes, B1, B2 may be an option, but
Children's
I generally,
education. Many times, if you've lived in this country for this long, you chances are you already have a US citizen kid or two or three,
yeah,
right? What happens to that? Because I feel like if someone is being compelled to leave the country, then the US government is literally compelling the US citizen out of the
mm,
country, right? So isn't
yeah.
that crazy?
Sure, if that's what I'm saying. If you have true intent to go back, B1, B2 can be an option. But if you don't want to go back, if you just want to have some time so that you can look for another job or find another job, then there is another option that attorneys are telling people, that's switching to F, student visa. Or if you don't want to switch, your spouse can apply
Mhm.
for a student visa, and you will get dependent,
Right,
basically F2 status, so that you can stay. Spouse can work, study, and you can stay in the US, so that you have time to locate or find out jobs. Maybe you don't go for F, your wife can go for F, and you will get dependent visa. That's one other option if you want to evaluate.
right.
Um, then Then there is uh, some something called compelling
I
circumstances,
wanted to
EAB.
get to that. That
Yeah,
is as crazy as it sounds.
yeah. It's not a new visa. It's not a new program. It came in 2017.
Yeah,
Historically, it was never for uh, layoff or job loss, and it was for some people, like someone who is on H or some other non-immigrant status
yeah,
and has the I-140 approved, where your um, priority date is not current.
right,
So if you face some extraordinary circumstance which is compelling, and which warrants USCIS to basically exercise discretion to give you some time and authorization to work, like not the job loss, maybe harassment,
right.
employer harassment, right? Um, Somebody has died, like suppose your H1 spouse has died,
Uh,
medical emergency, suppose you were on H1 and maybe you had an accident and
right,
you cannot go to work for some time, maybe
right,
for next 8 months, or or a year or 2 years.
right,
You have partial disability. Some uh, again, and compelling circumstances. They did not define compelling circumstances, so it's the thing is, it's totality of circumstances test. So you have to prepare your case in such a way
yeah,
that USCIS says, yes, this is something serious, and we should give him or her some time to uh,
right.
get back on track.
But this is also a two-edged sword because if you do apply for compelling circumstance, chances are you might not be able to get back to your visa status, the prior visa status, right? You might get the EAD, hey, you can continue to work. first, which I feel is so difficult to just even prove to USCIS that there is a compelling circumstance, because there's absolutely no guideline, and it's at the discretion of the officer who's reviewing your case, really. If you think about it, whether they're going to agree to a compelling circumstance or not, or depends on the kind of pressure you're putting on them, right? So I feel like first to even prove it to them that, hey, I am in an extraordinary circumstance, because think about it in the layoff scenario. This is outside of people's control. If companies are laying off, mass laying off, right? This is not in anybody's control, and at a time when opportunities aren't as available as you would like them to be, so you can switch jobs easily. That's not happening either. So I just don't get it. I just don't understand how would compelling circumstance fit into this scenario.
So every situation has some red flags to it.
Right.
F status has some problems to it. B status has some problems to it. And compelling circumstance, yes, the moment you use the EAD of compelling circumstance, your status is gone. Now
Hmm.
you need another stamping. Suppose you use the EAD, meaning you apply for EAD, that will not affect your current status. As long as the EAD is pending, you will be in status, whatever status you hold right
Yeah.
now. Once the EAD is approved and you start using it, that's when you basically change yourself to this status, and then your current status is lost.
Right.
Meaning, if you want to go back to your H status, then you have to go out of the country and then get a new visa stamping. You cannot adjust, you cannot change your status back to H in basically in the US.
Once
That's one
you're
caveat.
And that's when you're no longer eligible for the EAD. Is that when all of this comes into
Now,
play?
once you use the EAD,
Yeah.
once you use the compelling circumstances EAD, which is approved,
Yeah.
so if you don't use it, you're fine. But the moment you use that EAD,
Mm-hmm.
that means you just have for that the visa that you hold is no longer valid.
Got
Now
it.
you cannot go back inside the US. You have to leave, and then you have to go to for a stamping, and then you can come back on that same visa.
Okay. This sounds excruciatingly painful to me.
Yeah.
But how does one maintain the EAD status under the compelling circumstance EAD, so that this situation doesn't come? I mean, and do they really get the green card after that, or no? Or this is just for
No,
a
you cannot
limited.
adjust. You
Oh,
cannot adjust. It you they basically USCIS gives you EAD for 1 year, which can be renewed, but again you have to explain why you need uh, an EAD of that nature. We call it extraordinary remedy, meaning it's a compelling circumstance, right? So,
yeah.
as I started with this statement, desperate times call for
Yeah.
desperate measures. So you have to again prove your circumstances that fits with the requirements of the EAD. Once you do that, then you can get extension. Same again, 1 year. If you have 1 year, basically I-140 is approved, and you have like around 1 year of
Right.
uh, pendency of your priority date, final action.
Right.
Okay, then you don't have to really show compelling circumstances. Then you can get it renewed for 1 more year.
Right.
But otherwise, you would have to prove everything.
See, that's the situation most Indian born nationals are stuck in, because we don't know when the dates are going to be current again, right? And
Yeah.
this seems like, that there's not much chance, really. So if you really have to go for compelling circumstance, it'll help you navigate maybe in a year or two. But beyond that, it's going to become really difficult unless you can really find a change of status somehow.
But but I would say
Yeah.
it, basically it's a very good option for someone who doesn't want to leave, but needs at least 4 or 5 months, because what I see generally, if you lose a job,
Yeah.
technically it takes around 2 to 3 months, maybe 4 months to find a new job.
Yeah.
So if somebody wants to stay here and wants to find a job and get back on track, it's a very good option. It can be a very good option, because when once you apply, you do not accumulate unlawful presence,
Okay.
right?
Yeah.
Suppose you are laid off today, and you tomorrow you apply, you have 60 days, right? So 60 days technically, if you have stamping, if your
Yeah.
status is like more like maybe a year or two, and you are laid off today, then you have
Yeah.
60 days grace. And within that 60 days, if you apply for this EAD, then you do not accumulate unlawful presence.
Right.
That stops, and processing can take up to 6 months, 5, 6 months, 7 months, right?
Okay.
So what happens during that time? You have 60 days. Suppose you applied on the 30th day, and then you can have 3 or 4 months and you find a job. You don't need this EAD anymore. We can withdraw the
Okay.
application, and you can continue your um,
Status.
journey.
Yeah.
Yeah, your status with the new employer.
Yeah.
Yes, you would need a change of employer and extension, but at least you do not have to go outside for visa stamping. Basically, just applying does not impact your status.
Okay.
Meaning
That's
you
good
need
to
to,
know. Yeah.
yeah, you need to understand this thing,
Yeah.
that again, first of all, I would like to tell everyone, this does not create attorney-client privilege.
I was
I'm
gonna
not.
say that you said my lines.
Yeah, basically, I'm not giving legal advice
Yes.
here. I'm telling whatever I believe is true, my understanding of compelling circumstance EAD, and my understanding of immigration
Yes.
law. I can tell you that um, just the application, submission of application does not impact your status.
Okay.
Once you acquire that status, that's when you lose your H or other non-immigrant status,
Okay.
not before that.
Okay.
So the time duration you have between your application and pendency, the good thing is that you continue your basically you're not in status, you
Yeah.
are authorized to stay. You will not accrue unlawful presence.
Okay.
And once you get a job in like 3 months, 4 months, 5 months, and the EAD is pending, the moment you get a job, your application is
You
filed,
can
the
just withdraw
transfer,
it.
you withdraw your EAD, and
Yeah.
then you will be fine.
But if you get an approval, then the whole thing
If you use it,
changes. Yes, if you
if
use
you
it, okay.
use it.
Okay, so even if you get the approval and you still don't use it, it's okay. You're safe.
But the moment I would say it's a tricky situation. Once you have an approval,
Yeah.
you basically will use it, right? Because
Right.
if you don't use that EAD, then what's the point, right? Then
Right.
there is no
And also for
status. There's nothing.
USCIS, I mean, think about it. Also for USCIS's, records, it shows that this was given to you. This was approved for you. Now,
Exactly.
if you have not used it, that's your problem. But this was approved in their records, right? So
Yeah.
before we go any further, really, I want to give away a disclaimer. The discussion today is for informational purposes only. It does not create any kind of attorney-client relationship. Whatever discussion is happening today is just for your benefit. Your particular case may be very different, right? We don't know what your situation is, but looking at the way things are around us, all this news that we are hearing about, people being so distressed about their visa status, we decided to come together and start discussing about this so that you get the right information right from an attorney, and you know what could be the next course of action for you depending on the kind of situation you are in. And if you want to reach out to attorney Ishan Anand, I'll be leaving his information in the description box, or you could just comment here and I'll get back in touch with you. My next question will be: have you ever filed a compelling circumstance EAD?
I have not. I have not filed because if you talk about when it came into existence, right? job loss was never an option for this. It was not a reason where you can, okay, I lost a job, so I want to apply for compelling circumstance EAD. It was just to there were different
Scenarios,
basic
reasons for which,
reason
yeah,
scenario where you can file but not job, because right now the reason why people are talking about this EAD, because now it's not regular job loss. It's like
yeah.
thousands of people are getting laid off. So
200,000 just in
yeah,
January.
yeah. So
200,000 people. Wow.
it's
Yeah.
it's a mass layoff. So that's when you can actually use that to apply, but not just one thing that oh, I got laid off. No, I would say once you try to apply it, you basically apply it with saying, we have a home loan, my
Yeah.
job, I don't have a job now, my kids go to school, my wife is housewife, she's not earning, something like that. And meaning, like, give so many reasons and then apply, sure, you will get it.
So can someone, and this is just hypothetical, if someone's on H1, the wife's on H4. Now, not everybody on H4 gets an H4 EAD unless you have, certain criteria that you fulfill. Now, can that H4 visa holder go ahead and request for an EAD under compelling circumstance?
I remember back in the day, people used to tell, basically, attorneys used to tell that if you do not have much income on H1, your spouse can apply for an EAD, even if the spouse is not eligible. They used to do
Really?
it.
Really?
But USCIS, I've never seen any approval on that, but I remember people used to apply this kind of EAD. That was not compelling circumstance, but in EAD where you are just trying to say, basically tell USCIS to exercise discretion
Yeah.
and give you some relief because your household income is not enough
Yeah.
to survive. But well, in this case, compelling circumstance EAD, uh, you said the spouse does not have EAD. The
Yeah.
thing is, compelling circumstance EAD, first requirement is the I-140 must be approved.
Oh, okay.
Okay,
Then you can
so
apply
if
for an H4EAD in that case.
exactly, so if the
Yeah.
I-140 is approved and it's backlogged, then spouse can apply for an EAD
Yeah.
anyway.
Yeah. Yeah. Okay.
So
Okay. Makes
yeah.
sense. Okay. A lot of people have also been talking about changing status to an F1 visa, which you had also pointed out to in the beginning of our discussion. So, what does that entail? How does that safeguard their visa status? And I personally feel, you've lost your job. And if you go on to another master's program, second or third in this case, because most of H1Bs already have a master's degree, they're also, kind of using up their savings, which they, might have saved all these years, right? So, what do you have to say about change of status to F1?
So I have seen people getting 70-80% of scholarship with F. All right. So that's one thing. And I usually tell people to not themselves, but the spouse go for the F. But in this case, if you do not have any status, spouse will lose it.
Yeah.
So yes, you would have to go. And yes, you can actually transfer. You can change your status to F. And once you go on F, then there are different things like on a CPT. You can only work with CPT. You can only work on OPT. It
Yeah.
depends on your basically course and your college, and because they know if you can work or not. They know if you can work on CPT or if you can work on OPT because that's their job. They do it every day, all day long,
Okay.
365 days.
Yeah.
So once you enroll, they are better to guide you what's gonna work, what will not work, because they
Yeah.
are also the one who provide you the documentation to apply for the EAD.
Right.
So
Right.
they would know. I would
Yeah.
say when you transfer, just talk to them first.
Okay.
Regarding the case, oh, course, not case,
Right.
regarding the course, and then the EAD type and what you can do, because
Right.
most likely you will be only doing the um, less hours, and then prescribed you can only work for some category of
Yeah.
employers,
Yeah.
not everyone, and in your field only.
Yeah. Well,
So
at least there are some options. It's not that it's the end of the road of a tunnel. So there are certain options if you are in this situation, which is very unfortunate. But if you are in such a situation and you don't know what to do, I'm hopeful that this discussion today, would have helped you in some way, shape, or form. If you have any particular questions for us, please send them to us in the comment section, and we'll be happy to answer any of those. Attorney Ishan, thank you so much.
I would like to add some more things
Yeah,
here. Okay,
absolutely.
so uh, not just these options, I also sometimes recommend self-petitioning.
Hmm.
Right, there are self-petitioning options like EB1. You
Yeah,
may be eligible. I'm not saying that you will be. No, you have to evaluate basically, we have to evaluate your case if
yeah,
you are eligible for EB1, maybe national interest waiver. It's very popular these days. Now, the problem with Indians and Chinese is that even if you are NIW approved, it's an employment preference number two, which
yeah,
is again backlog. So it
yeah.
will not help Indian and Chinese. But if you are from other country, some other country, and you get your NIW approved, you are eligible for green card. You can actually file your green card concurrently with your
Right,
petition,
right,
right? If you are a professor, you can file your EB1
right.
as an outstanding researcher, professor, So, mm, meaning there are options.
And this
There are
can be a topic of discussion in itself, how to
different.
self petition under EB1, how to evaluate, how to create, those markers for yourself so that, the 10 guidelines that USCIS has. How do you qualify for not just three, but maybe four or five or even six so that that makes your case stronger? And I feel that could be a great discussion topic for another time, Ishan. Don't you think?
Sure, yeah,
Yeah.
but it's an option. If you are
Yeah.
thinking that you are thinking about an option, I would say that consult with an attorney who can evaluate. Maybe you are qualified for EB1. Maybe you are qualified for national interest waiver.
Yeah.
Something like that.
Okay. Okay. Perfect. Perfect. Thank you so much for your time today. Thank you so much for
So
doing this
thank
with
you.
me today. And
Thank
I hope it's been of help to you. Again, if you have any questions for us, send them to us in the comment section, and we'll be more than happy to help you, guide you. Again, this is not legal discussion. This is just for informational purposes. This is just so that you know what kind of options are available for you out there. And if you want us to talk about a particular topic, want us to discuss something that you want clarity upon, just put it out in the comment section, and I'll be happy to create a topic of discussion around that. And until next time, I will see you around. Stay safe.
All right. Thank you so much. Thank you.
Thanks,
Bye.
Ishan.